Judgment in the matter of an application by Dennis Hutchings for judicial review.
Lord Kerr will explain the decision of the court.
On the 15th of June 1974, in the late morning, a young man called John Patrick Cunningham was shot and killed near the village of Eglish in County Tyrone, Northern Ireland. He had been standing at the side of the road when a two-vehicle army patrol containing members of the Life Guards Regiment of the British Army approached. Mr. Cunningham, who it later transpired had a mental age of between 6 and 10 years, appeared startled by the approach of the army vehicles. He ran across the road in front of the lead vehicle. He climbed a gate into a neighbouring field and he ran towards a fence. It was later discovered that he was running towards his home. The commander of the army patrol was the appellant, Dennis Hutchings. He ordered the patrol to halt, and three members, including Mr. Hutchings, pursued Mr. Cunningham. After shouting a number of commands to stop, Mr. Hutchings and another soldier discharged shots. Those shots struck Mr. Cunningham, and he died instantly. Subsequently, it was established that not only did he have limited intellectual capacity, Mr. Cunningham was unarmed. And since he was running away from the soldiers, he presented no threat to them or to anyone else. Now, in 1974, there was a great deal of terrorist activity in Northern Ireland. A large part of this was generated by the Provisional Irish Republican Army. And 2 days before the killing of Mr. Cunningham, members of the Life Guards Regiment, again under the command of Mr. Hutchings, had found a group of men loading material into a vehicle. A firefight, as it has been described, between those men and the army patrol ensued. And after that firefight had ended, a search of the vehicle was carried out, and arms and explosives were discovered. A number of investigations into the killing of Mr. Cunningham have been conducted, but it wasn't until 2015 that Mr. Hutchings was charged with the attempted murder of Mr. Cunningham and with attempting to cause him grievous bodily harm. On the 20th of April 2016, the Director of Public Prosecutions issued a certificate under Section 1 of the Justice and Security Northern Ireland Act 2007. And that certificate directed that Mr. Hutchings should stand trial by a judge sitting without a jury. Section 1, subsection 2 of the 2007 Act allows the DPP to issue such a certificate under certain conditions. So far as concerns the present case, the DPP must suspect that one of a number of stipulated conditions has been met. He must also be satisfied that in the light of that suspicion, there is a risk that the administration of justice might be impaired if the trial were to be conducted with a jury. The relevant condition in this case is condition 4, and this is the way in which it is expressed in Section 1, subsection 6 of the Act. And I quote, "Condition 4 is that the offence was committed to any extent, whether directly or indirectly, as a result of, in connection with, or in response to religious or political hostility of one person or group of persons towards another person or group of persons." That is an extremely wide provision. It covers offences committed to any extent, even if indirectly, in connection with or in response to religious or political hostility of one person or group of persons. The Provisional IRA campaign in Northern Ireland was based on that organisation's political hostility to continuing British rule. And the incident which had occurred a few days before Mr. Cunningham was killed bore all the hallmarks of a PIRA operation. The DPP considered that this condition was satisfied. It's entirely unsurprising that he should have done so. The offences with which Mr. Hutchings has been charged were deemed to have been connected with or in response to the political hostility of members of the Provisional IRA against those who believe that Northern Ireland should remain part of the United Kingdom. This court has concluded that the DPP's decision that Condition 4 was satisfied cannot be impeached. That conclusion is reinforced by another provision in the Act, that is Section 7, subsection 1. Section 7, subsection 1 provides that no court may entertain proceedings which question any decision of the Director of Public Prosecutions for Northern Ireland in relation to the issue of a certificate that trial should take place before a judge sitting alone, except on the grounds of A, dishonesty, B, bad faith, or C, other exceptional circumstances, including in particular exceptional circumstances relating to lack of jurisdiction or error of law. Apart from the arguments that Mr. Hutchings' legal team advanced on the proper interpretation of the statutory provisions, they also contended that he ought to have been provided with the reasons that the DPP was minded to issue a certificate, and with the material on which the DPP's consideration of that question was based. They also claimed that he should have been given the opportunity to make representations on whether a certificate should have been issued before any decision about it was taken. The Divisional Court in Northern Ireland dismissed Mr. Hutchings' challenge to the DPP's decision. He appealed that decision to this court. We unanimously dismiss his appeal. The breadth of the power under Section 1 of the Act is unmistakable. The DPP need only suspect that one of the stipulated conditions is met and that there is a risk that the administration of justice might be impaired if there was a jury trial. These decisions can be of the instinctual, impressionistic kind, while the DPP must, of course, be able to point to reasons for his decision. Under the terms of the Act, that decision can be based on unverified intelligence or suspicion, or on general experience, rather than on hard evidence. The circumstances covered by Condition 4 are likewise extremely wide. They cover offences committed to any extent, even if indirectly in connection with or in response to religious or political hostility of one person or group of persons, as I've already said. The Provisional IRA campaign in Northern Ireland was based on that organisation's political hostility to continuing British rule. And the incident which occurred a few days before Mr. Cunningham was killed bore all the hallmarks of a PIRA operation. It was, therefore, as I've already said, entirely unsurprising that the DPP should have concluded that the offences with which Mr. Hutchings is charged were connected with or in response to the political hostility of Provisional IRA members against those who believe that Northern Ireland should remain a part of the United Kingdom. As to the argument that Mr. Hutchings should have been told that the DPP was minded to give a direction that he be tried by a judge sitting alone, Section 7 of the Act expressly provides that a judicial review challenge, as I've already said, is only admissible on grounds of bad faith, dishonesty, or other exceptional circumstances. It was accepted that this is not a case of bad faith or dishonesty. But Mr. Hutchings claims that the case falls into the exceptional circumstances category because of what he says is the fundamental right to a jury trial. there is no such fundamental right. The fundamental right is to a fair trial. While one is normally entitled to a jury trial, deprivation of that entitlement does not make this case an exceptional one. This is especially so because the very purpose of the 2007 Act is to prescribe the circumstances in which someone can be denied the right to a jury trial. There are no circumstances in this case which could be said to be exceptional within the terms of Section 7, subsection 1c of the Act.
The court will now adjourn.